Respected dignitaries, on the today's webinar, staff and my dear student friends, a very pleasant evening to you all. Let me first introduce myself. I am Joshna Sri, studying first year at SV University, Department of Law. We are honored this evening by the presence of our distinguished chief guest of the day, Ms. Sonia Mathur Garu, Senior Advocate, Supreme Court of India, Senior Executive Member, Supreme Court Bar Association. We are also honored with the presence of our eminent guest of honor on today's webinar, our beloved principal of SVU College of Arts, Professor B.V. Muralidhar Garu, distinguished guests, delegates to the webinar, my dear friends, and all the participants and students as well from the other colleges. It's indeed great pleasure to welcome you all to this webinar on evolving jurisprudence on capital punishment. This webinar is organized by 5-year BA LLB Department of Law students. Without any further delay, let us begin this webinar. Now I give over to Jita Maitreyi. She will say the introduction about SV University. Jita Maitreyi. Okay, let me continue with the introduction also. So first of all, thank you everyone for coming here today. I am very privileged to take a part in this meeting. Coming to the introduction about our prestigious university, Sri Venkateswara University, Tirupati. It's established in 1954 to cater the educational needs and aspirations of people of the Rayalaseema region of Andhra Pradesh in the world-famous holy temple town of Tirupati on the sprawling campus of 1,000 acres with a panoramic and pleasant hill view. The university has grown excellently from the strength to strength over the past 66 years. It has gone through greater strides in the transformation of the university with acquiring necessary and modern sophisticated instrumentation to catch up with the world competition in academic and research programs. After completing 66 years of excellence in teaching, research extension, and outreach activities, from a humble beginning of one college with 6 departments, the university has now grown into the second largest university in Andhra Pradesh, having 4 constituent colleges: College of Arts, College of Sciences, College of Commerce, Management and Computer Science, College of Engineering, accommodating 54 departments offering 72 programs. Besides strengthening and existing curriculum, now courses are being planned under MERU Miru program. So this is all about the introduction about our prestigious SV University. Now I give over to Vasavi, who will introduce our distinguished guest of today's webinar, Ms. Sonia Mathur Garu. Vasavi. Vasavi, please unmute yourself. Thank you.
A warm greeting to everyone. I am Vasavi, student of SV University, Department of Law. It gives me a pleasure to introduce my chief guest of today's webinar, Miss Sonia Mathur Garu. Our today's guest speaker, Sonia Mathur Garu, is an senior advocate designer designated by the Delhi High Court in 2017 with over 3 decades of experience as a lawyer. Apart from the Supreme Court of India and various high courts, ma'am has also specialized tribunals for income tax and competition of laws, and prosecutor for cases relating to the name as can be appointed as special prosecutor for the cases related to the 2G spectrum scam because before the tribal court, High Court and the Supreme Court. She was the standing She was the standing counsel for the Central Bureau of Investigation (CBI) and senior standing counsel for Income Tax Department before the Delhi High Court. Um, Ma'am has master degrees in labor law and from the University of Rajasthan, as well as masters in taxation from the Washington of Law. Ma'am is regularly invited to a National Judicial Academy. Bhopal was a resource for practicing special judges CBI. Judges presiding over the motor accidents client tribunal and also visiting judges from over countries. Ma'am has been argued 4 cases as a CBI lawyer for former part of the compilation prepared by a Delhi High Court in 2011 to 12 to enact contribution of Delhi High Court to the development of law. Asif Malwa versus CBI, Bimal Batwal versus State, and Ravinder Kumar Chandolia versus CBI, and Sanjay Tripathi versus CBI. Ma'am was a part of the editorial team for the 11th edition of Kanga and Palkual on the income tax. Ma'am has been appointed as mucus curia in the death sentence caused by the Supreme Court, and Ma'am is also an elected senior member of executive at the Supreme Court Bar Association. Thank you for giving this opportunity, and warm welcome to the Ma'am Sonia Garu.
Thank you,
Thank you.
Vasavi, for introducing our distinguished chief guest. Our webinar is all about the evolving jurisprudence on capital punishment. So here, capital punishment, also called death penalty, execution of an offender sentenced to death after conviction by a court of law of a criminal offense. Capital punishment should be distinguished from extrajudicial executions carried out without due process of law. This is all about the today's webinar topic. Now, I would like to call upon our distinguished chief guest, Ms. Sonia Mathur Garu, to have a talk on our webinar. Ma'am, please.
Thank you very much for a very, very kind introduction, and very warm greetings to Professor P.V. Muralidhar and all respected faculty members who've joined us, and the other guests, organizers, and very, very dear students. First of all, I must compliment you. I was just impressed hearing about your university. Great heights you have achieved, and I must compliment and congratulate you for that. And thank you very much for also giving me this opportunity to be a part of a young crowd. Although I would have loved to do it physically, but I think this is one thing which COVID has given us. So maybe given a chance at any later stage, I would love to come physically and meet everyone. So the topic that I have chosen today is certainly not a very interesting topic to be talking about after lunch. And I will have an additional responsibility of keeping everyone awake right after lunch talking about death penalty. But nevertheless, I'll try and make it interesting enough for everybody to at least keep awake. Now, as we all know, that it's a highly debated topic so far as death penalty is concerned. There is a school of thought of academicians and intellectuals, activists who don't really approve of this mode of punishment. But then the fact remains that we still have it. Although there are a number of countries who have done away with death penalty, but in our country we still have, and there are various offences under the Indian Penal Code where death sentence can be awarded. And apart from IPC, there are also other acts such as NDPS Act, POCSO, where death penalty can be awarded for different offences. Now, I've had occasion to do some of the cases, to appear in some of the cases where the accused concerned was awarded death sentence. But I'll talk about them later on. They are not a part of this presentation, but I'll still talk about it later. And so far as this presentation is concerned, I'll be more than happy to share with anyone whoever wants it. I'll share it with one of the organizers, and maybe then you can access it. Now, otherwise, there is plethora of judgments on, and it is just impossible to discuss about all of them and the legal principles which have been laid down in all these. But I've just made an attempt to pick up few judgments which I thought could be interesting enough to discuss. So I think we'll just start with the first slide. Now, this was a judgment. I'll just tell you a little bit about the facts of this case. This was a case where there was a young lady who had been whipped out of her husband's home by her father-in-law, and she was living with her parents and her only child. So she committed a murder of another young woman and her child because of some rivalry between them, and there was some aspect of an illicit lover. So in this case, at the stage of sentencing, the Supreme Court had considered certain positive indicators against death penalty in the Indian context. And they considered age, which was one, and the second was socio-economic conditions. So far as age is concerned, it continues to be a consideration even till today, whether it be at a young age or the old age, it is considered in favor of the convict. And the socio-economic condition also continues to be a mitigating factor till today. In this case, the sentence awarded was death. However, Supreme Court had commuted it to life imprisonment. And then this was another case where the dispute was within the family, and two persons were killed from one family. The accused was granted life imprisonment. However, when he was out of custody on the occasion of Gandhi Jayanti, he again murdered a friend of the family. So it was in that background that the initial sentence was life imprisonment, but subsequently he was awarded death sentence because of the subsequent offense, and he was considered to be a menace to the society. And however, Supreme Court had again commuted the death sentence to life, and it was only in this case that the concept of reformation was considered. Before this case, the reformation concept was not considered. And also, in this case, the court considered Section 354(3), which broadly says that if a sentence of death and a life sentence has to be awarded, then court has to give reasons. But when it comes to death sentence, if death sentence is being awarded, then the special reasons have to be given. So this was a case where Supreme Court discussed special reasons under Section 354(3). And also, Justice Krishna Iyer acknowledged this, that, whenever we have white collar crime or corporate criminals which sort of, through their economic or environmental offenses pollute much bigger category of victims, harm much bigger category of victims, but they are not given death sentence. And you will maybe right now you guys are still students. Well, you'll read later, and once you come in practice, you'll realize that in white collar crime, deaths are not given, regardless of the amount involved. But in this case, a majority had commuted death sentence, but Justice Sen had given a dissent, and he had upheld death sentence. Then Bachchan Singh was another case. Some of you must have heard the name. This was a batch of petition where constitutionality of the death penalty was challenged, and the court was pleased to uphold the constitutionality. That's the reason that we still continue to have it on a statute book. And in this case, although in Rajendra Prasad case, which I mentioned, that the special reasons for awarding death under section 354(3) were to be recorded. So on that Rajendra Prasad judgment was ruled in Bachchan Singh, and it was on the limited aspect of that the special reasons need not be relating to only the criminal. They have to relate to crime. Now today the theory is it is crime and the criminal both. And in this case, 4 accused were given death sentence because it was considered to be rarest of the rare cases. In this case, actually, the individual, so far as Bachchan Singh is concerned, in this particular judgment, they did not either confirm the death penalty or commute it to life imprisonment for the reason that this was a batch. So then the Supreme Court decided the issue of law and then, relegated it to the respective benches to decide the facts on facts of each of the case. But in this case, there was one thing that the court held was that life imprisonment is the rule and the death sentence is an exception. And before awarding death sentence, a balance sheet has to be drawn. Balance sheet of the aggravating circumstances and the mitigating circumstances for each. Now, so far as this aspect of death penalty is concerned, this is really evolved. I'll tell you later in the later slides as to how this has evolved. Now, the next is Machi Singh and others versus State of Punjab. Now, so far as facts of this case are concerned, there was series of attacks. You can read what the slide says. I'll just in the background tell you a little bit about the facts. In this case, in 1977, August 1977,
లేదమ్మా కొంచెం
I'm sorry.
కొంచెం అన్నం లేదా
So in August 1977, there was a series of attacks that took place in around 5 villages in Punjab. And the attacks were all organized by this person who was Machi Singh. And because he had a feud with some other person and his sister. So he was the one who planned this attack. And in this attack, total 17% were killed. And it was only after that Machi Singh was arrested. Now, in this case, again, the Apex Court discussed aggravating and mitigating circumstances and laid down certain principles which were to be followed as guidelines while deciding whether death sentence has to be given in murder cases. 5 categories broadly were laid down by the Honorable Supreme Court to say that, these are the consideration where society might, mandate the judges to impose death sentence. And these categories were the manner of commission of crime, which is to be considered, motive for commission of crime, nature of crime, and magnitude of crime and personality of the victim. So these 5 categories were created. And then comes this Swami Shraddhanand. This also maybe students in the later years of college would have heard about this. This is also quite a talked about judgment of 2008. In this case, the husband had actually killed his wife when she was 40 and basically gave her a sedative and sort of buried him in his own house, in the backyard of her house. And the body was recovered 3 years later when her skeleton was taken out from the backyard on a complaint by her daughter. A missing complaint was filed. So in this case, the court emphasized on the availability of sentences other than life sentence and death penalty. And they considered the concept of alternative option. Excuse me. Alternative options were considered, and thereafter, in a number of cases, the court has taken a view whether the life to a person's natural life sentence should be pertaining to the entire natural life, or number of years can be given as opposed to death penalty. Then there are a number of cases which are not possible to sort of, deal with each and every of them, but where the courts have considered brutality of the of the manner in which the offense is committed, and they have categorized certain nature of crimes as rarest of the rare cases. Now, there is another very interesting part of jurisprudence relating to death penalty, which is section 235(2) and 354(3). Now, one is where the court is required to give reasons, particularly when death sentence is being awarded. So, a very curious study has been made over several years whether if the sentence is awarded on the same day, today I'm convicted, and on the same day, if sentence is also awarded to me, whether it would mean that the obligation which is laid on the court to separately discuss the sentencing aspect has been discharged by the court or no. Now, in this case, this is the case of 1974, where the accused had committed murder of his mother and mother's second husband. So he was sentenced to death on the same day. So now the Supreme Court was examining whether on the facts of this case, the requirement of 235(2) have been met or no. Now, under the old code, what was required was that an accused was required to submit whatever he had to before the arguments were concluded, which means that before the arguments on conviction are concluded, the accused was required to give whatever he had to give. Now, under section 235(2), under the new code, an opportunity was to be given to the accused specifically. He had to be heard on the question of sentence after he's convicted. Now, Tagdu was another case, Tagdu versus State of Maharashtra. The facts of this case were extremely brutal. In this case, in fact, 4 women who were aged around 30 years and 5 girls aged around 10 years and a one-year-old girl. They were all killed, and their private parts were cut to make some sort of a sacrifice. So it was in that background that the court was considering the aspect of death sentence having been given to them. And it was considered to be rarest of the rare cases considering the brutality involved. Here also Supreme Court observed that accused were convicted and the court was required to hear him on the question of sentence, but they did not do it. So they were considering the aspect of whether it was open to the higher court to sort of rectify the breach, or they could do it themselves. So in this case, the case was remanded back and the accused were permitted to adduce evidence before the court, adduce all the data that they wanted to produce before the court. So that was one aspect. And in this case also, in Malkiyat Singh also, since he had been in custody for 6 years after the conviction, court felt that, there was no requirement to remand the matter back to the special court to consider the death sentence, but they commuted the death sentence to life imprisonment themselves. And they also held that when a sentence is awarded on the day of conviction, it was not in accordance with law, and it would normally have the effect of remanding back for reconsideration. This has, of course, now has undergone some change, the approach of the courts. Now, specific observations which the court made in this case with regard to the section 235(2), I have quoted that part where the court has said that state of mind of a person awaiting death sentence and the state of mind of a person who has been awarded life sentence may not be the same mentally or physiologically. And here the court went 2 steps ahead. The court said that it is not only on the accused, or not only on the accused to produce material to say with regard to his mitigating circumstances, but Supreme Court went on to say the court has the duty and obligation to elicit relevant facts, even if the accused has kept silent. So even if the accused doesn't produce material with regard to his mitigating circumstances, the Supreme Court said the court has a duty and obligation to elicit these facts. This is we all know Nirbhaya's case, Mukesh versus State of Delhi. This is a case where death sentence was awarded and it has even been executed now. In this case, also the aspect of same-day sentencing was argued. So the court considered two options before it. One was that they remand the matter back. Now, a long time had passed, and the second was that they direct the accused person to produce the data and advance their arguments before the Supreme Court itself. So Supreme Court had adopted the second approach, and they gave an opportunity to the accused person to file affidavits with the documents and bring out their mitigating circumstances. So this was the Nirbhaya's case, and this just indicates the current approach by the Supreme Court that when so many years have passed by, the person has traveled from the session court to the High Court to the Supreme Court. So now at this stage, to relegate them back to the special judge for considering mitigating circumstances, Supreme Court took it on themselves, and they considered the affidavits and all of that and came to a conclusion that this case did not require any other consideration. This Muhammad Manan is a case of 2019, which is much later case. In this case, there was slight change in the approach by the Supreme Court, and they say that same-day sentencing by itself will not vitiate the sentence, because what has to be ultimately seen is the spirit of the section, spirit of the statute. That it can't be so mechanical that it's same-day sentencing, so therefore sentence is vitiated. The court says what has to be examined is whether the hearing given was a meaningful and effective hearing or no, whether an opportunity was given to properly advance the mitigating factors and the court has actually considered the mitigating factors or no. So this principle of meaningful and effective hearing came into existence, meaning it was not that mechanically same-day sentencing, meaning the case goes out of the window. So it was not that it would be mere formality. Now, in 2020, there was a study. Some of you could be aware of this. There is a Project 39A in National Law University, Delhi, where they do a lot of work on death penalty, sentencing, etc. So they had examined some trial court judgments in 3 of these states, which is Delhi, MP, and Maharashtra, between these 15 years. And they realized that MP, which is Madhya Pradesh, had same-day sentencing to 76.9% of the cases where same-day sentencing was awarded. So therefore, the impact of the same-day sentencing has an immediate bearing on the mitigating circumstances. And this study noted that in 41 out of the 60 same-day sentencing cases, no mitigating circumstances were considered. Now there are a whole lot of the categories which we can say fall in the which qualify as mitigating circumstances and aggravating circumstances. If there are multiple offenses and then the brutality, but it's not all the time that brutality weighs with the court. I'll just share with you my own experiences where I have done these cases and which I thought were brutal enough, but the sentence has been commuted. Now then the third aspect, which has the third aspect, which is which can be discussed here, is the constant review. Normally, Supreme Review petitions are disposed of in chamber and they are not really oral hearings which are given at the stage of review. But this was one judgment in 2014 where the constitutional bench recognized the right of a convict under Article 21, and they said that that continues to be available to a convict even at the stage of review petition, for the reason that the death penalty is an exception, and considering the irreversible nature of the penalty, because a person is, if the death penalty is executed, that's the end of the matter for that person. So considering all that in mind, the court allowed oral hearings. So now review petitions which are filed in the Supreme Court against death sentence, they are given an oral hearing. So what the court observed was interesting observation. So I thought I'll just share with all of you. The last para, it says that when a convict who has suffered the sentence of death and files a review petition, the necessity of oral hearing in such a review petition becomes an integral part of the reasonable procedure, because you cannot convict a person unless the procedure in law is followed. So the court evolved this concept of reasonable procedure when it comes to granting oral hearing to a convict who's sentenced to death. Recently, we've had this, I'm sure some of you must have read about it. It was very famously quoted everywhere: every sinner has a future, and saint has a past. The Supreme Court, in one of these cases, had commuted a death sentence to life imprisonment by making these, by observing these, this quotation. The only difference between the saint and the sinner is that every saint has a past, and every saint has a past, and every sinner has a future. And in this case, the offense involved was rape and murder of a 4-year-old, and the lower court had granted death sentence, which the High Court was, which the Supreme Court was pleased to commute to life imprisonment. A review was filed against the judgment because there was some amount of outrage somewhere that, you know, in a heinous crime like that, the sentence should not be commuted. But then that review petition has been rejected. Now, there is also another development which okay, now this was one case of 2022 where Justice A.M. Khanwilkar's bench has confirmed a death penalty, which has happened after a fairly long time. This was a case where the court considered and found that the aggravating circumstances outweighed the mitigating circumstances. And predominantly, the reason for that was that this person was, even post conviction, when he was in jail, he was undergoing his sentence, he committed murder of another inmate, hit that person with stone and killed him. So the court said that, you know, if somebody who has these kind of traits, then there is no scope for reformation. This kind of a person will not change and will continue to be a menace to the society. So after a very long time, in 2022, the Supreme Court has confirmed death sentence. But then also simultaneously with this, there is another approach which is being evolved by the Supreme Court, and which is of, you know, when the person is undergoing sentence and waiting for his execution, waiting for his death penalty, death sentence to be executed. So at that stage, the court considers his socioeconomic, his psychological behavior, and his behavior in the prison, all of this. So for this, they have, you know, there is a mitigation investigator. There is some class of professionals which are mitigating investigators. They visit the convict in the jail and discuss with them, their psychologist, and you know, they would sort of evaluate the mental state of the person, not at the time of offense, because obviously that's a defense. If somebody has to take a defense of mental instability or something like that, then that has to be taken at the trial stage. But even at the stage of execution of the death sentence, the court, there is a theory where they have, you know, psychologists meet the convict and evaluate their mental health. So in this case, this was one case which was pending, and an application was filed for giving access to a mitigating investigator. application was filed saying that this mitigating investigator, who's not a lawyer but broadly a psychologist, should be allowed to go and meet the convict in jail and make an assessment. So now the Supreme Court has converted that IA into a suo motu writ petition. And now what they are discussing in court is that access to mitigation investigator be given at the stage of trial. Wherever death penalty is given, the court is looking into this aspect, that wherever death sentence is given, access to the mitigation investigator be given as a matter of practice. And then in this case now they've issued notice to Attorney General and also to the Civil Service Authority, which is legal aid. So coming to the just about a couple of cases which have been done by me, where death sentence has been commuted to life imprisonment. One was of 2021. I don't have a slide, but if you want to read it, I can share the citation with you. It is 2021, 1 SCC, page 596. This is name of the case is Shatrughan Baban Meshram versus State of Maharashtra. Now, in this case, the victim girl was just about 2.5 years of age. She was and the accused here was her maternal uncle, which here this side of the country we call him Mama. I don't know what you call in South, but we call him Mama. It's like mother's brother. So he was the convict, and it was the offense. The rape was so vigorous that the injuries to the genitals were very, very grave, and that child obviously died. So, but in this case also, after considering the law laid down in Bachchan Singh, Machi Singh, Swami Shraddhanand, etc., some of the cases that we've discussed, the court commuted death sentence to life imprisonment broadly on the ground that there is a section called, if you read the definition under section 300 of murder, there's 300 fourthly. So court said that this was one, a case of circumstantial evidence because there was no eyewitness there. And the second was that the intent was not to kill. Intent was not to kill the child, but intent was to commit the offense of rape. That eventually led to death of the child. So it was on this ground, and also they had done some socio-economic evaluation of this person, and death was commuted to life imprisonment, and that person is still undergoing life imprisonment. He's now rigorous imprisonment awarded to him for 25 years. So instead of death, he undergoes 25 years of imprisonment. But his behavior in jail was considered because he had done some courses, some studies, etc. So the court considered all of that and then came to a conclusion that there is a scope for reformation so far as this person is concerned, so commuted. And the other case that I have done, I think this judgment came in 2022 only, if I'm not wrong. That I don't have a citation of this. It is Virendra versus State of Madhya Pradesh. And in this case, also the accused was maternal uncle of the child, and the child was 8-year-old. It's a case of 2022. I've just been informed by my colleagues, and she was also raped and died because of asphyxia, and died also because of the injuries which were caused to her during rape. So in this case also they had commuted, and in fact in this case I was given access to I had e-mulakat with the convict while he was in jail in Jabalpur, and it was so depressing to even talk to him, because the kind of conversation that I had with him, because in some of the jails the prison rules say that whoever is a death convict on the death row, then they are not given any responsibility, they're not given any work. So this person, when I asked him, I said, "What do you do?" So I can talk about this case because the judgment is out. So I have no limitation in that sense. So I asked him, "What do you do?" So he said, "Nothing. I don't do anything." He said, "Kuch nahi karte hain," because he said, "I'm just waiting. I've already been given death sentence, so I'm just now sort of waiting to go." So I asked him about his family. He said he was 10 years of age when he had started working. And he said, my father was working in some government office as a peon or as a cleaner, I think, as a cleaner. And he used to go in the morning and come back in the night when most of the time he used to be drunk. And he used to beat my mother, beat all of us. And, these kind of socio-economic condition that, most of the people on death row, either they are, of course, they fall into category of terrorists, or they're mostly from this section of the society which has almost similar condition, similar bringing up. And in this case also, then since he wasn't really qualified, he hadn't read anything, so he said, "No, I don't read anything." But and the other reason which weighed with the court for commuting his death penalty to life imprisonment was that this was also, if I remember, I don't know if I remember correctly, probably it was a case of same day sentencing, but the prosecutor had placed all the facts before the court at the stage of arguing on sentencing, had placed all the mitigating circumstances, but the court did not consider. So Supreme Court, this also was one fact which weighed the Supreme Court to say that the mitigating circumstances had not been considered. So there were three, four reasons for commuting. One was that it was a case of circumstantial evidence. Second was that it did not fall in the rarest of the rare category. And the second was, the third was that proper attention was not given by the trial court while considering aggravating and mitigating circumstances. So he's been now sentenced to undergo life imprisonment for a period of 30 years. So the first one is undergoing sentence of 25 years. This one is undergoing sentence of 30 years. And another case which I am still waiting for the judgment, it was a case of gang rape and murder, where the trial court and the high court both, there were three accused, three young boys, but all of them have been sentenced to death. And this happened, I don't know how many of you are familiar with the Nirbhaya's case, but this happened after, some time after Nirbhaya. So it was pitched to the same level in the social, this thing, in the media, and that it is another Nirbhaya which has been. So there was a lot of public pressure which was created, and they were sentenced to death. But now I'm still waiting for the judgment, so I will not talk much about this case because it is still pending decision by the Supreme Court, and I think that's about it. And if anybody wants to ask me anything, I'd be happy to answer, and I'm really grateful for this opportunity, and I just hope that I've been able to make some sense. And but I'll be happy to share the presentation, whoever wants, and I'll maybe share it to Mr. Kalyan and share it with him, and whoever wants can. And look forward to physically coming to your university someday.
You're most welcome, Mrs. Mathur. It's one of the best places in India.
I'm sure. I've been through Tirupati.
Yeah, we have the richest God in the world.
I have been to Tirupati
Earlier it used to be Vatican. Now Tirumala has overtaken Vatican.
Okay.
We have around 1 lakh pilgrims per day, roughly. 50,000 to 1 lakh floating population.
Yes, I know. It's a beautiful place and truly divine.
Yeah, definitely. Kalyan, discussion between the
Okay, sir. Joshna, you can.
Yeah.
Ma'am, it's indeed pleasure for us as well to have an interaction with you. Thank you so much for an enlightening speech, ma'am. We know that you are a terrific speaker and we had a great discussion on today's webinar, Evolving Jurisprudence and Capital Punishment. Now I'd like to ask all the participants to chase the golden opportunity to interact with ma'am and ask few doubts regarding today's webinar. Is anyone interested to ask doubts?
Please, one request on behalf of everyone. Make the question very brief, just one line. Don't ask the question like an answer. That's what I have seen in many of the programs like that. Because people will be giving almost giving an explanation or asking the question also. If you want to ask any question, be very brief, or if you want to say something, say it within 1 or 2 lines. Your comments are also welcome. You may accept what she said, you may not accept. You are free to comment. But be respectful. This is only an academic exercise.
हेलो मैम, आप जो
Yeah, please.
हथरास रेप केस के बारे में कुछ बता सकते हैं क्या मैम?
किसके बारे में सर?
हथरास रेप का
Can you switch on, please? Sorry. Can you switch on your video, please? Those who are asking the questions, please switch on your videos so that we can see. Hemshekhar.
सर मैं camera is a problem. My camera problem, sir.
Okay.
No problem.
Others, please switch on the videos. You are asking the question to madam.
Yes, Mr. Sekhar, what do you want to ask for Hathras rape case? See, that's also another case which is still pending. I think the conviction was done by the lower court, but I think the appeal is pending. But that was a case of 2020. If you just want to know certain facts about it, where a 19-year-old girl was gang raped in Uttar Pradesh, allegedly by 4 upper caste men, and then she died 2 weeks after in a Delhi hospital. But I think the trial court is already convicted, but the appeal is pending in the High Court, if I'm not wrong. I think this is what it is. Yes. Any specific question that you want to ask me about this case? I'll be happy to respond.
तो हमको तो एक डाउट है मैम, आप जो पहले बताया था केस का बारे में, अभी 22 में केस हुआ था एक छोटी लड़की का, वो तो पहले से जजमेंट तो हो गया, लेकिन ये तो बड़ा क्या बोलते हैं लोग तो पॉलिटिशियन का इन्वॉल्वमेंट है इस केस में, इसलिए थोड़ा लेट हो रहा है, हमको थोड़ा डाउट है इसलिए।
इसमें conviction हो गया sir, and so far as you know, I really am not in a position to say comment on who was involved and who was not involved, because this is all, you know, I can certainly discuss law with you, but so far as facts of a case are concerned, particularly when the case is still sub judice, it may not be appropriate for me to comment on who was involved and who was not.
डाउट मैम, सुप्रीम कोर्ट में होने से भी जो पॉलिटिकल का इन्वॉल्वमेंट रहता है क्या, सुप्रीम कोर्ट में होने से भी पॉलिटिकल इन्वॉल्वमेंट?
See, I'm sorry. Morning. I'm sorry, but these kind of general, I'm not in a position to respond to these general comments about the politics and the politician. I'm a very simple lawyer.
वही तो मैम, हम लोग भी आपका भी आने वाला था ना मैम, इसलिए आप लोगों जैसे आप पूछने से हम लोग की भी अच्छा रहता है ना, थोड़ा पूछ के।
Have more your interaction with the conflict in this case? Ma'am, can we have more insight about Hello, am I audible?
Yes.
Ma'am, can I have more insight about your meeting with the
Which case?
conflict?
Sorry, I'm not able
You
to
are not audible, ma'am.
hear you.
Case.
Inside,
Senior Mathur.
you're talking about my communication with these
No,
convict?
ma'am. Some participant.
Wait about your meeting. Yeah. Your communication with this convict.
With the convict, huh?
Yes, now you are audible, ma'am.
Okay, my conversation with the convict, which I said that I had e-mulakat with him when he was in MP.
Yes.
Okay. So I asked him because I wanted to basically make out a case. I was representing him. I was appointed by the Supreme Court. It was not a private case, so I really had no economic interest in the matter. But so I wanted to help the process. I wanted to help the process of law. So I spoke to him. I said, "What do you read? How do you pass your time?" I thought if he does anything constructive, if he's not able to read, that's fine. But if he's doing any other way he's contributing in the jail, even if he's doing some manual labor or guarding or anything like that, gardening for that matter. So I asked him, I said, what do you do? But he was so dejected and disappointed with life apparently, because he said, from last question I understand that probably I can drop in a little bit of Hindi also. So he just said that फांसी हो गया मैडम, अभी क्या बोलूं, फांसी तो हो गया. So, he was, and then I asked him about his family. So his wife had left him. He had a wife, but his wife had left him, and his brothers were also there. They were also not communicating with him. So it was only his mother. It was only his mother who was in touch with him. So I placed before the judge as this also one of the mitigating circumstance by saying that he still is in touch with his family is in touch with him, so he'll be welcome today if you leave him. So there is somebody who's ready to welcome him back into the society. And because these people spend so much time in custody that sometimes they lose touch with society. So because when they are on death row, they are not let off like this. Even they of course can have visitors. So in this case, mother was the only one who was visiting him. So I placed this fact before the court as a mitigating circumstance that he's still in touch with his family. So that was it, that my discussion about and then of course his own life, whatever he told me about his life, honestly I'm telling you, I couldn't sleep that night. I couldn't sleep at all, because here also we were talking about somebody who had allegedly raped an 8-year-old niece, and absolutely no hope with him. And then the fact that this question kept bothering me, that I'm defending him, but what if he's actually done it? It's not easy. So society has a very different way of looking at it, which includes people like us. So it wasn't a very pleasant experience communicating with him, but yes, I did. Anything else?
Hi, ma'am. Good afternoon.
Good afternoon.
My name is Pranava Krishna, ma'am.
Yes.
And
Excuse me. Yeah, that's good. Thank you.
Yeah, I'm the student of Mahila University, Tirupati, ma'am.
Yes,
Sri
ma'am.
Padmavati Mahila University. I have only one question bothering me always is like there are so many laws which prohibit the crime in the society. We have so many laws prohibiting the crime in the society, but yet there is a incline, or I could say rate of increase in the crime happening every day. Let's talk about the sexual abuse, right from the infant child to the elderly women. They are getting assaulted. The question bothering me is there should be certain changes made probably in the probably in the penal code or the procedural code or something. There should be some, I understand reformative theory of punishment is good, but there should be some changes to get the fear in law to the normal society. I mean, if I am not asking this question, wrong asking this question, ma'am.
No, not at all. See, one thing is that the very reason that we are still holding on to death sentence, despite the fact that it has been abolished in so many countries, and despite the fact that it's really a current, it's always been a current topic of discussion, but we are still holding on to death penalty, is that we feel that it can have some sort of deterrent effect on the mind of a criminal. And apart from that, I think there are a number of factors which contribute. It is not only because the law is doing its work, right? But then there are a criminal trial has various segments, has various sections. It has three independent AGs. One is investigation, one is the prosecution, and then of course we have judiciary. So investigators do their job, and then it comes to the prosecutors, then it comes to the judiciary. So every section of these three steps, these three segments of criminal trial work in a totally different way. So far as the genuine cases going bad in the sense that where the actual offender has sort of been let off. It could be for any lapse by any of these agencies. It's very difficult to pinpoint. I'm telling you my own experience. I have seen cases where the investigation has been so shoddy that even when you know for a fact that yes, this is the person who's done it, but then as a lawyer, what do? You can only place, because you are not a judge, you are a lawyer. So you can only place what is given to you by way of evidence. So even if you know in your heart that yes, this is the person, you will only place the evidence before the court and then let the judges do their job. And so far as the increased rate of crime is concerned, there also I would say there are multiple factors which contribute. It's very difficult to pinpoint or identify one which we can sort of rectify or one which we can change overnight. There are multiple factors which contribute, and I'm telling you, most of these cases where purely out of my personal experience, these cases where there is a case of child rape or even gang rape, which I'm saying I'm still waiting for that judgment. So even there, they are all they come from a different section of the society, different strata of the society, where either the education is missing, and I mean their socio-economic conditions are very, very peculiar. Very peculiar. So I don't know whether directly or indirectly they could also be contributing in their. How do you explain if somebody who's sort of a mama or a maternal uncle of a 2.5-year-old child, how do we even explain that somebody would commit an offense like that? So I just hope we can wait for a society where the crime rate will go down. I mean, we were thinking that since the laws were made more stringent after Nirbhaya, we were thinking that at least the sexual offenses would reduce. Doesn't seem to be like that, because we still keep hearing. But I think it's a long way for us to go. I'm hoping that we'll get there somewhere. I don't know if I've been able to answer your question, Ms. Pranav Krishna. Let me know if there's any other aspect which you think I can answer in a more.
You've been absolutely a great help, and from the beginning of this session, it was a wonderful session and got a lot of inputs actually I mean, you put us in the place of you as a person talking to an offender and talking to a victim, and you explained us all those things. So I as a person used myself in your place, and I could see the difference. Thank you so much for this wonderful session, ma'am.
Thank you very much, ma'am. Thank you.
Amareshwari, one of our colleague from the LLB. Yes, you can go ahead, Andy. Amareshwari. I think you have raised your hand. Kalyan, మీ మేడం ఏదో క్వశ్చన్ అడగాలనుకుంటుంది.
Yes, sir, but yes.
కళ్యాణ్ వినిపిస్తుందా?
వినిపిస్తుందండి. You can go ahead.
Madam, when this accused oriented system will turn into victim oriented system, coming to conviction rate only 2%, less than that. So we are always witnessing the accused having the number of rights, constitution itself. Of course, we are not denying the basic rights, every human being having so many rights. So when Britishers framed these laws in 1860s, so still we are continuing, we are forgetting totally about the victim, and victim is secondarily victimized. The accused-centric system, when it will be turned into victim-oriented system. And another question is the death penalty, whether the capital punishment be continued or abolished in India? And so many countries abolished this because some person has committed theft, I may not commit theft. So because some person has committed rape or something nasty, I may not commit that same thing. Whether basically amnesty reasoning or based on humanitarian grounds, because he committed that one, I should not repeat the same thing. I should not be the abettor present at the scene of the offense. I should not be 133 IPC 133 accomplice, co-accused person. So again, giving the same punishment to him, or based on the humanitarian grounds. So I had only the capacity to give the life to any person, whoever may be. That person may be brutal, or but I have no energy to kill, or whether the capital punishment is valid or it should be abolished. So whether so many doubts, madam. So I'm permitted.
So, ma'am, if you were asking for my personal views about death penalty,
it should be abolished, madam. Whatever I need.
Please,
you think
my request once.
abolished?
Yeah, my
Okay.
request
And I'll
once
ask
again.
your
All
name to
the
project 30.
my request to all the participants, please make your questions very brief. If it is not a question, I think you can take 1 minute to give your opinion. Don't ask 2 or 3 questions simultaneously to the speaker. Please.
Madam, when
Yes, ma'am.
accused oriented system, victim orientation, when we see.
Ma'am, see, to my understanding, it is victim-oriented system to the extent that there is some victim compensation provisions which are in place, where because once a damage is done, your dear one is lost, you can't be compensated in any other way. No amount of money can compensate the loss of your dear one. When you see your daughter, I mean, particularly talking in the context of these cases, that the ones that we've just discussed, when you see your dear one is lost, he's lost his or her life, you can't be compensated in any other way. But yes, the CRPC does have the victim compensation system, and also the rights of the victim have been acknowledged, because now there was an amendment sometime back in the CRPC where even the complainant has a right, supposing if the trial court acquits an accused, so and the state decides not to challenge. So regardless regardless of that, regardless of the state challenging it or not, the complainant, the victim, can directly file an appeal and challenge it. So that is another thing. And so far as this concept of social conscious is concerned, it is a talked about concept that, you know, what the society would look at, what the society would expect a judge to do. Because even now, wherever there are like very brutal offenses committed and the Supreme Court commutes it to life imprisonment, there's a lot of backlash on social media. A lot of people comment and criticize that, you know, this is what they do, this is what they do. So this concept of social consciousness is social conscious is very subjective. Like I said, you know, when I communicated with that convict, when I had that e-mulakat with the convict, I couldn't sleep the entire night. Maybe somebody else in my place would not have felt the same way. So, so far as society at large is concerned, every individual has a different way of responding to a particular situation. So we can't really generalize that part. And you are right that the system is more predominantly in favor of the accused. That is probably the reason. The reason for that could be because there are a lot of handicaps that an accused, because most of these cases that I have spoken about, where I have appeared at the Supreme Court level, everywhere, most of these cases, the assistance given to the accused was by way of legal aid. The families were not even in a position to afford a good lawyer at their cost. I'm not at all suggesting that they did not get the right legal assistance. Legal aid lawyers are also very good. But what I'm saying is they could not afford a lawyer. So probably that is the reason which weighs somewhere, because the accused has, you know, once you put somebody behind bars, then there are a lot of limitations that that person would have as compared to a person who's outside. And the criminality and the culpability is still to be judged. You know, so we cannot come to a conclusion at the outset that yes, this person has done, this person is not done. So therefore, because we're still waiting for the outcome of the trial, I think the system weighs more in favor of the accused. And so far as the laws are concerned, I think Parliament is certainly after Nirbhaya, there were a lot of amendments made, and the laws relating to rape were made much more stringent. And I guess but they'll pay some time, and the system is definitely more stringent now after Nirbhaya. But you are right, there is the corresponding decline in the sexual offenses, at least we don't see as of now. I hope I've answered your question, ma'am.
Yes, ma'am. Now, Joshna, you will go on to.
Ma'am, thank you so much, ma'am, for your enlightening speech and clearing doubts of our participants as well. Now, I would like to welcome our beloved principal, the eminent chief guest of today's webinar, SVU Arts College Principal B.V. Muralidhar Garu. Before Sir speak, I would like to give an intro about Sir. Sir is an editor, the International Peace and Development Studies Africa. Sir was reviewer, International Journal of Social Science and Humanities, Singapore. Sir was also reviewer, review projector, India. Article editor, Sage Open Publications, USA. Sir was the director, Directorate of Student Welfare and Cultural Affairs from September 2008 and conducted 11 SV University Intercollegiate Youth Festivals. Sir has also organized Inter-University National Youth Festival in January 2011 as director, and 64 universities have participated in it. Sir has also conducted quiz event in 18th Agri-Inter University National Youth Festival in February 2018. 47 universities have participated. Sir was also the head of Department of Political Science and Public Administration, SV University, from September 2014 to September 2016, and from September 2019 till date. Sir is the chairman, BOS Dravidian University from 2016 to 19. So far, 4 programs are organized as a part of Azadika Amrit Mahotsav. Celebrations 2022 in SU University, Tirupati. Sir has also organized second international conference on constitution and social responsibility mapping 75 years of India's independence, the occasion of Golden Jubilee celebrations by Department of Political Science and Public Administration collaboration with Department of Sociology at SV University Tirupati in 12th and 13th March 2022. Sir was also the chief guest on celebrations on Water Conservation Day 2022, organized by BT College Madanapalli. Sir is immensely talented, a sports personality, and we feel always grateful to have such an immensely talented principal at Arts Block. Sir, I would like to ask you to have a talk on our today's webinar, and could you please give your valuable take on today's webinar?
Yeah. Thank you very much, Ms. Josna, for your kind words. And I think I'm just a teacher who is learning the subject of political science and public administration. That too, my specialization of international relations and foreign policy, which I've been teaching for the last 32 years. So I joined in the department in 1989, November 9th. This is my 33rd year as a faculty. And those from, I think from other universities, from Mahila University, I can openly tell them that I'm a husband of Professor Mamata, your registrar. You'll be surprised to know. I don't want to say she's my wife, I want to say I'm her husband.
We know, sir.
Yeah, that's the reason.
Good afternoon, sir.
Yes,
That's
thank you
always
very
safe
much.
for sir.
Yeah, for those who do not know me. And warm greetings to the main speaker of today's webinar, Mrs. Sonia Mathur ji, Senior Advocate of the Supreme Court, New Delhi. Team Kalyan, I can say, because I'm a sportsman, I don't want to say LLB and all those things. It's a Team Kalyan, like Team India, Team Blue, and Team Aussies, like that. So Team Kalyan, who have been doing extremely well for that age. This is the third webinar which they have organized. One was Rai, the other one, one lady from South India who is working in Supreme Court. The third one is Mrs. Mathur. So thereby all the members of the Department of 5 years LLB program of my university and other universities, invitees, academic consultants, faculty members, young student friends, ladies and gentlemen. And I'm out of box. I'm not concerned with your law aspects, but politics and law go together, as the speaker was telling. And someone raised the question also, whether politics gets involved. Yes, normally, when law wants to take its own course, with all what you call as a due process of law and everything going on perfectly, some element of politics will always step in. And once that element steps in, the justice get diluted. I have seen n number of cases, and I follow very well. Just for example, as I told my students sometimes, the Salman case, Salman Khan, that guy in the Jodhpur, his bail application was rejected. And I was just watching that case because I follow that I was following that case for a very, very long time. I know he can buy justice, and he has a very big team of battery of lawyers who can argue either in favor or against him. So once the Jodhpur session, it was around lunchtime, and he has only 3 or 4 hours to get the bail again without going to jail. And I was just thinking how this guy is going to manage. And as my gut feeling went, he managed. He came to the battery of lawyers came to Bombay. Then they took the bail before 4 p.m. He was out. And he has a very, I'm not saying it's not pertaining to him only, because this is a very famous case. And he is as human. That's a very funny thing. And people have a fans for him also. And there is one more case which I've been following, the Kerala nurse sodomy case. She was in a vegetative stage for 40 years. So pathetic. She was harassed in Mumbai in 1970s. She died in 2015 or 2016. I followed that case also. And unfortunately, friends, let me tell you as a common man, the guy who was an attendant in that hospital was left free. And I have seen on TV that guy when he was left free and walking in his village fields, and he did not feel anything. As my colleague Amareshwari was telling, that's what I want to tell you. The people guilty feeling has completely gone, more or less. Even when they have committed the most heinous crimes, because they know somewhere or the other there is a light, a ray of hope for them to escape. Yes, that is happening everywhere. Let's forget about other countries, but in our country, as I have seen for the last 30-40 years, whether it is white collar or blue collar or whatever color crime is being done, the person who commits that, he knows pretty well they are going to get scot-free one day or the other. So thereby, what I feel is that when a crime, or when you have the rarest of the rare cases which the judges, the honorable judges will be talking when they're delivering judgment, I personally feel there should be capital punishment. Because after 14 years or 15 or 20 years, whatever the lifetime is, once you come out, there is no guarantee that person will change or has changed. When I was in US, I have seen the Californian jail. They have 2 points of capital punishment. One is through lethal injection, the other one electric chair. And in US, in all the states, there is a debate going on whether capital punishment should be abolished or not, as it is going on in India. There are many people who feel that the guilty or whatever, the accused or whatever you call it, the person who has committed crime, whether it's a man or a woman, they should be punished. If that punishment is not there, I personally feel that the change is not coming in the human beings. That's why, as one student or faculty from Mahila University was telling, yes, what's the fun in having? Why this is increasing? Forget about safety for women. There is no safety for men also on the roads nowadays in our country. If such is the scenario in 2022, just imagine how it will be within 3 or 4 years. So now it's open for all the participants and others who are present here. Just think for a while whether capital punishment should be there or not. Human consideration is okay. Nobody has a right to take away the life of the other person. But suppose for me, how can I have the right to take away life of someone X or Y? When I'm asking my right of life to be protected by the Constitution or by the judiciary, what business I have to take away the life of a girl or a boy or a man or a woman, whatever may be the circumstances? So this is the question which everyone has to answer. And I'm very happy that Team Kalyan has taken up one more debatable topic, which will be there always among the legal experts as well as the academicians in this country and elsewhere also, and all the young student friends who have taken up this initiative. And as the speaker was telling, it's very difficult to sit after lunch, very difficult. And I think she has almost successfully made us to stay awake till now, till 4:10, 4:15, like that. Thank you once again.
Thank you, sir. Thank you so much.
And you are most welcome to our department. Right, Roy Saab wants to come to Tirupati. Maybe in August, he's planning to come to Tirupati.
I'll
and we'll be
talk to
having a
him.
talk. He's a good friend. Yeah, he's a good friend of VRC Krishnaya Garu.
Yeah.
So we'll be
I'll
having a talk with to the students when he visits Tirupati in person. In the same way, whenever you have the time, you can just
Thank
put
you
a
so
word. Don't mind taking care of you.
Thank you
So
so
thank you
much.
once again, Kalyan and Jyotsna and others, for your nice intro
Thank
and making this possible. And I hope we'll have one more next month, maybe
Thank
by
you
the end
very
of this
much for giving me this
August.
opportunity.
Thanks a lot.
Ma'am, thank you
Thank you
so
so
much,
much,
ma'am,
sir.
for accepting my request, especially a student
My
request.
pleasure.
I'm very grateful for this, ma'am. Once again, thank you so much. And today, a really very nice session. Really, we didn't expect this much of long time, ma'am. We hope definitely we will meet physically in future also. Behalf
Absolutely.
of our professor sir and my college mates and students, our university, we are cordially inviting you, ma'am. Please accept our request whenever you are free.
Certainly.
Please,
Certainly.
ma'am, and
It will be my
want your
pleasure.
support in future also, ma'am.
Of course, definitely. So,
Ma'am.
yeah,
Joshna, you can.
Thank you so much, sir. Thank you so much, ma'am,
thank you.
for your contribution on today's webinar. We feel so
Thank you.
grateful to have you on this webinar. And now I'd like to head over to Devi Priya for vote of thanks. Devi Priya.
Thank you, Joshna. A warm and grateful afternoon to everyone. I am Devi Priya, a student of SV University Department of Law. Today, it's my privilege to propose vote of thanks and acknowledge the contribution of those who work really hard in making this meeting possible. First of all, I would like to thank our speaker, Sonia Mathur ma'am, for your valuable time, giving us your valuable time and making your thoughts to visible, sharing your knowledge with us. It's been a very great opportunity for us to hear you, ma'am.
Thank you.
And I would also like to thank our chief guest, Principal B.V. Muralidhar sir, for your presence in the seminar and having your thoughts on today's topic, sir. We know you are a very grateful person, sir. And also thank our dean, and I also like to thank our dean Krishnaya sir, who is unable to attend the meeting today, but always grateful for sir and for guidance and support. And also I'm happy to thank all my professors who motivated us and encouraged us in doing this meeting. Last but not the least, all the students who participated in this meeting and cooperated with us. Thank you so much. Thank you, everyone.
Thank
Thank
you.
you, Devi Priya.
Thank you
I
very
once
much.
again extend my heartful thanks to the distinguished chief guest Sonia Mathur Garu and eminent chief guest of today's webinar B.V. Muralidhar Garu for your presence, and I extend also my thanks to all the participants, students and students from other colleges as well. Thank you for all your contribution, participants, and making this webinar a huge success. Thank you everyone. Thank you so much.